Just so we can finish up the 2-year session and everything, and also our two years worth of meetings in here, I want to make sure all issues have been addressed. JD, have you ever directed any of your staff not to talk to the legislative branch or any members of the legislative branch?
Certainly not framed in the way you've suggested the question. I think relative to some of these conversations, I had conversations with Justice Wood at some point during this process when I think it was after Mr. Welch and Ms. Robinette had appeared before you and were asked to come back, and she asked me to basically receive those requests and let her know so that we could get the right person to you. That was part of what led to our suggestions that it might be better to have judges come and answer those questions rather than AOC staff. And in addition, Justice Wood chairs the Supreme Court's Committee on Children and Youth, and so I certainly could have said to staff members, if you receive a call, let me know and let me respond. And I think I had a conversation with Ms. Holiday about saying the same thing, to ask her to let me know if staff members were needed to be here so that we could, so that I could be aware of it and we could respond.
And I appreciate that, because good communications prevents poor communications. But let me just ask you this way. Is there anything that prohibits us, as far as you're concerned, from having access to any of your staff or anyone else as far as direct contact with them? Have they been given any directive?
Certainly not.
Okay, very good. And I want to, just my final question is going to be to Misha, if I may. Judge Brown said something a while ago, and I was going to ask him, but they were needing to get out and get to their docket, so I'll save the question for you. One of the things when we talk about resources, one of the things we heard, and this is not a criticism, it's not a tag, it's just trying to get a statement of fact out there that if we are going to have the discussion about resources, why more resources are needed. Judge Brown was asked a question about, well, how much of your time is consumed, or the judges, specifically Judge Brown answered it, how much of your time is consumed by prescription drugs and, you know, underliers that are causing people to come back into the courtroom and taking up a lot of their docket time. How much of the judge's time is taken up because attorneys for DCFS are coming in and sometimes only have enough time to prepare the day before, and when they get before the judge does the judge's job and says, this isn't enough, go back and regroup, and it's almost like a perpetuating cycle because your attorneys don't have enough time to prepare before they come before the judges so that they can get it settled sooner than later. Is that an issue that the resources are going to help address, or where are we with that?
So I can speak as formally supervising the attorneys that represent DCFS. I don't actually supervise them. Jerry Sharon and David certainly are here. You know, just from our prior experiences, the attorneys that represent DCFS are overwhelmed and do have large caseloads. The part of the plan that we submitted for additional financial resources was for the DCFS budget. We did not ask for, through the DCFS budget, funding for Office of Chief Counsel, so they have a separate budget within DHS.
I guess we do offline conversations, because moving forward into the general session dealing with the budget that's going to be coming up, Judge Brown and all the judges kind of perked my interest on that you can, if you don't have well-prepared attorneys going before a well-prepared judge that has 32, 38 years of experience, you're fighting a losing battle before you ever walk into it. So I would like to have that offline discussion with you about the resources that are needed to that level, because maybe if we could get more help at that level while we're throwing a lot of money toward caseworkers and everything, if we don't address that issue, we're just shifting the problem down the road until that poor attorney stands before that judge and have to deal with what they're doing. Am I off on that? Is that a fair perception?
That is absolutely a fair perception. You know, I talked with you guys the last time I was here about one of the pilot programs that we're doing in Sebastian County called Rapid Reviews, and that's a review of the kids that are very close to permanency. And what we're finding is part of the bottleneck for those kids is the ability to get timely orders, to be able to get petitions filed, to be able to get the adoption legal information to the court. So, I mean, that falls with OCC, or the Office of Chief Counsel. That's who represents this responsibility, and frankly, they're very overwhelmed in Sebastian County. So yes, part of discharging kids from foster care more quickly is a partnership between the caseworker and the attorney.
Okay, Mr. Chair, I'm getting it quick, but one other thing that was mentioned in here is about you get a family straightened out, okay? And I know there's underlying issues, and I know you're dealing with a culture over there that, you know, it's going to be a process to bring the best to the top, all that stuff. But you get a family straightened out, and the judge says, okay, go forth and live your life. 30 days later, they're back in front of them again because they either ran out of resources or, you know, something happened. Is there anything that we need to do at looking, giving judges a longer extension of time over a family to bring them back longer on a monthly checkup so that it's not as time absorbing if those families come back later and it takes up more time?
Right, so judges already have the discretion to leave a case open after they return custody. And in fact, that's best practice and what DCFS should be recommending to the court. So just because a child goes back to their parent through a dependency neglect case does not mean that the case automatically closes. And our best practice recommendation is another 6 months of the court monitoring the cases. I did, as Senator Williams was asking one of the judges about reoccurrence of maltreatment, re-entries into foster care, I did go ahead and look at last year's data related to DCFS. So last year, state fiscal year 2016, 44% of the cases concluded with reunification with a parent. An additional 28% of those cases, the kids went with relatives in their custody so that the relative would have the child long-term permanent custody, case closed, stay with relative. 9% of our investigations of maltreatment do have a reoccurrence of maltreatment. And then when you're talking about foster care, we only see a 9%. In 2016, following cases from the previous year, so within 12 months post foster care, only 9% had entries back into foster care, and that is at the national standard. So we're doing a pretty good job of preventing re-entry in foster care within a year.
Okay, let me just say, because maybe last time you're at the table for me to say, is appreciate the job you're doing, and we'll continue to work together, and thanks for your frankness and answers to the questions. Thank you, Mr. Chairman.